Hello, my name is Joshua, and today I'll be evaluating Priceline's user agreement. Also known as their terms and conditions, I will address key legal questions such as whether this agreement forms a valid contract, whether their users are bound by it, and whether you can sue Priceline in the event of a dispute. I'll also be recommending a few changes to improve the clarity and fairness of the agreement. So, naturally, we have to ask, is it a valid contract? So to determine whether Priceline's terms of use form a valid contract, we must look for essential components. So mutual asset, consideration, and legal capacity. Okay? So looking at mutual assent, Priceline's terms and conditions are present to users when they visit the website, right? And while Priceline uses a browse wrap agreement, meaning that users are assumed to have agreed to the terms by using the website, this method can still be considered valid in many jurisdictions. However, there is some legal risk because some jurisdictions may require explicit consent, such as clicking I agree. This legal precedent, you can kind of look for examples. There's courts in the US that have upheld these browse wrap agreements in cases such as Spectre v. Netscape Communications Corp. In 2002, where the court ruled that users were not bound by a contract unless they had actual notice of its terms. This case suggests that browse wrap agreements can be problematic if users do not explicitly indicate their consent. Now let's look at consideration. There's a clear consideration in this contract. Users gain access to Priceline services, and in exchange for payment, such as booking travel services, which fulfills the contractual requirement for consideration. 3, let's look at legal capacity. Priceline assumes that users are of legal age and capable of entering into a contract, which is typical in most user agreements. Therefore, this contract is generally valid, but there are risks related to the browse wrap method that could be improved by requiring active consent. Next, let's ask ourselves, are visitors bound to this, or should they have to click I agree? As mentioned earlier, Priceline uses a browse wrap agreement, and this means that by simply using the site, users are deemed to have agreed to the terms. While this is legally enforceable in some jurisdictions, it's not without issue. In contrast, a click wrap agreement, where users must explicitly click I agree, would provide clear and much more enforceable consent. The enforceability of browse wrap agreements has been subject of legal debate. In Nugent v. Barnes & Noble Inc. in 2014, the Ninth Circuit ruled that a browse wrap agreement was unenforceable because the user had not been sufficiently notified of the terms. This case reinforces the idea that users must have clear notice of the agreement, and a passive assent, like using a website, is not enough. If Priceline wanted to ensure maximum legal protection, they should consider switching to a click wrap agreement to ensure that users are explicitly bound to the terms. Now let's ask the question, can you sue Priceline? Priceline's terms of use include a mandatory arbitration clause, which means that most disputes are required to be resolved through arbitration rather than in open court. Arbitration is a process where an arbitrator, rather than a judge or a jury, makes a final decision. The enforceability of arbitration clauses has been upheld by the U.S. Supreme Court in cases such as AT&T Mobility LLC versus Conception in 2011, where the court ruled that arbitration clauses, including those that prohibit class action lawsuits, are enforceable under the Federal Arbitrations Act. This decision reinforced the idea that arbitration clauses are valid and class action waivers can be included in these clauses. However, there are limitations, particularly around unconsolable and fairness. Additionally, Priceline prohibits class actions. This means that even if many users have a similar claim, they must bring their individual cases. While arbitration clauses are legally enforceable, they limit the user's ability to sue in court, which could be seen as a disadvantage for consumers. The Conception decision and other Supreme Court rulings like Epic Systems Corp. Versus Lewis in 2018 support the idea that companies can enforce arbitration clauses with class action waivers. However, courts will still scrutinize the fairness of these clauses under state law, especially if they are deemed to overly one-side or unconscionable. However, Priceline does allow for small claims court as an exception, provided the claim falls within the court's jurisdiction. This gives the users options to go to court for small claims, but not for the larger, more complex dilemmas and disputes. In conclusion, users can't typically sue Priceline directly in the traditional sense due to the arbitration clause and class action waiver. However, they do have options for resolution through small claims court and arbitration. After reviewing the terms of use, here are my recommendations to improve the agreement. First, I would switch to a click wrap agreement. So, to avoid legal challenges, Priceline should switch from the browse wrap agreement to a click wrap agreement, requiring users to actively click I agree before proceeding. This would ensure clear consent and avoid legal ambiguity. Courts, as seen in Yugen versus Barnes & Noble and many other cases, have made it clear that active consent is the best way to avoid disputes regarding contract formation. 2. I would clarify the arbitration procedures. While arbitration clauses are common, Priceline should make their arbitration procedures more transparent and much more user-friendly. For example, Priceline should make it easier to understand how to initiate an arbitration, and possibly provide more information on how users can qualify for fee waivers or if they can't afford the cost of arbitration. Class action-wise, Priceline should reconsider its outright ban on class action claims. This is a controversial clause, and while it benefits Priceline, it may lead to negative user sentiment. Perhaps a middle ground approach would be correct, where users could bring certain class action for specific issues. That might be worth exploring. As seen in the conception of an Epic Systems, class action waivers are enforceable, but companies must be aware of public perception and potential backlash, especially if they appear overly restrictive. Privacy and data collection-wise, Priceline should strengthen the language regarding user privacy, including more specific details on data collection and how that data is used, shared, protected. These changes would help Priceline clarify its terms and improve the fairness of its contract with users. In conclusion, while Priceline's terms of use are generally valid and fair, there are some legal risks, particularly with the browse wrap agreement and the arbitration clause. By making the terms clearer and requiring explicit consent, Priceline can reduce their legal challenges. The arbitration clause, while enforceable, limits users' ability to pursue claims in court. So, modifying or clarifying that provision would be beneficial for both parties. Thank you for listening to my analysis. If you have any questions or thoughts, please feel free to reach out. I hope you found this review helpful, and I encourage you to review the full terms of use yourself to ensure that you understand your rights in regards to Priceline's service.